Hey everybody, Brian here. Coffee with the Disability Guys. Today I'm doing a little bit of a standing video shoot here. I've been sitting all day, so raise the old desk. I wanted to talk to you today about a change to the New York State law back in January that has actually a pretty big impact. So here's the background. If you had what they call a mental injury at work, you had like post-traumatic stress, or you developed severe anxiety or some type of phobia as a result of something that happened at work, particularly one where you were not physically injured, but that's not the only rule, but not physically injured, then that could only be a claim if the particular stress at work that you were, under was something that was greater than what similar workers would have been exposed to. So how did this work out to the negative? Well, let's take the MTA. The Metropolitan Transportation Authority always fights cases. So you have all these conductors driving subway trains that hit people. It happens a couple dozen times a year. Sometimes they stop before they hit a person. Other times, unfortunately, they kill people. And this happens far too often. However, the MTA always fights the cases saying that, oh, you don't have post-traumatic stress that's covered by workers' compensation because all the other conductors, I should say, actually train operators, not conductors, all the other train operators are exposed to the same thing. So this is not anything that's greater. And the courts have upheld this. That's nuts. So what happened was the law was changed recently, and it basically says that if you are exposed to extraordinary work-related stress, then you can file a claim, and you cannot deny the claim just because of the stressor. You have to show that it was extraordinary for your circumstances. So what does this mean in reality? Well, first things first, of course, we don't know what it means because they did not define the word extraordinary. But let's take a perfect example. Let's say you're perfectly healthy and both physically and mentally, and you are involved in an incredibly stressful situation at work. You're working at a bank, the bank gets robbed, and you kind of wig out. Okay, post-traumatic stress. Now, under the past rule, it would have said, well, that's really not unusual because all bank tellers are exposed to being robbed. Well, that was ridiculous. So here they said, was this extraordinary, right? Was this, yes, it was work-related stress, but was this extraordinary? Well, they could argue it wasn't, but maybe it was. Maybe the person was wielding a machete and a machine gun. Maybe you had a pre-existing condition that made some situation like this even worse and brought up all those past emotions. So the bottom line is this. If you have some type of stress at work, a situation that causes great or extraordinary work-related stress, you can make a claim. Now, the insurance companies are kind of scared because this is what they're thinking. They're thinking, oh my God, somebody's going to get yelled at by their boss and they're going to freak out and they're going to file a claim. That could be true, but is that really extraordinary? Now, if you could show that your boss comes in every day, throws crap around and yells at you all the time and yells at some other people, then that might be a claim. A one-off situation might not be. But then again, a one-off situation might be, and a course of action, bad action, might not be. Who knows? So here's the deal. If you have a claim based upon really significant, extraordinary stress at work, you should speak to a medical professional and speak to an attorney about making a claim if you have to get medical care or miss time from work as a result of that work-related stress. Just because other people are exposed to it doesn't mean you're out of luck anymore. So we're going to continue the good fight for you, and just wanted to let you know about that, and have a great day.